look at the attachments and oh, bless your heart. You should know.
That's pretty good. So you got done that here because she took
Tell
over.
me why.
Oh.
Yeah, I figured that would come.
That looks good. It's crazy.
It does it naturally.
That is moose and a hair dryer. And I just brush it up, brush it up, brush it up.
That's what I do too. Every
I
morning.
was looking to make it do that, but I know it's not that.
You probably have to take it around.
And you know, that's what I want to do. I was trying to do the curl in my arm like she does. I can never do it like
You would have to.
No,
wash
nobody
it.
can. No, I'm telling you, brush and,
Yours would have to be
Moose.
shorter. Yours would have to be stacked, almost.
yeah, it's stacked.
I don't think I can go much shorter in a hat all the time in the boat. And I tried to do it the other day.
Oh, I do not love that.
That seems with visors.
But I wear big hats.
Yeah,
I have a sombrero.
I do sometimes
I wear
too.
it. Yeah. We're talking out here. It's important stuff.
How are you?
Meeting is called to order. Escambia County Competency Board, April 2, 2025. Madam Secretary, do we have our rules today to review?
Yes, sir. Please silence all cell phones. If you wish to speak, please let the board secretary know in advance. Otherwise, raise your hand for the board chair to recognize your request. When the chairman calls you to speak, come to the podium, adjust the microphone, and state your name and address for the record. You are requested to keep your remarks brief and factual. Both parties of an issue will be granted uniform maximum time to speak, usually runs between 3 to 5 minutes. This hearing is considered quasi-judicial. Conduct is formal and profane or derogatory comments will not be tolerated.
Thank you. Do we have a determination of quorum this morning?
Yes, sir, Mr. Chairman, with 8 members present, we do. Mr. Patel is the only member absent.
Thank you. Do we have proof of publication of the meeting?
Yes, sir, Mr. Chairman, it was published March 27th, 2025 in the Pensacola News Journal.
Thank you. I need a motion for the approval of minutes for the previous meeting of March 5.
I motion for the approval.
Second.
Second.
I have a motion, a second. All in favor, raise your right hand. All opposed, same sign. Seeing none, hear none, motion is approved. Do we have anyone for public forum this morning signed up?
I did not receive any speaker request forms. You might want to poll the audience and see if anybody's here for public forum. But I believe everybody here is probably for an agenda item.
Okay. Is there anyone here for the public forum today? If not, we will move quickly forward. Madam Secretary, do you have a report for us for status today?
Nothing today, sir.
Nothing today. All right, contractor applications. We will move to that segment.
Good morning, Board.
Good morning.
Yes, indeed. The first application coming before you today is Mr. Albert Swetzuk. Mr. Albert Swetzuk, please come to the podium, state your name and address for the record. Available.
We did receive communication that he might not be present today. I offered the ability to call in and did not receive a response. You may notice that this name has been before you before. This is for a second review of his application for examination. He was previously approved to take the examination. However, after that time, we were contacted by the local field office for the Department of Business and Professional Regulation. They were curious if this person was licensed here. And when we told them no, that they had been approved to exam, they provided us with some additional information, which you would find in your backup. It's up to the board on how they want to proceed with this application. He was previously approved.
Has anyone had a chance to look at the background research part of this? Can you pull it up on our screen for us so that
Yes, sir.
if they have not, they can look at this? There was some surprises, I guess, that was not revealed to us.
That's correct. So in his application, he did not disclose any background history or issues within those within the questionnaire. DBPR provided us with this documentation or some of this documentation, and then we were able to obtain some further documentation from the New Jersey court. There is a news article in here, and it does pertain to a situation with contracting and payments to workers and things like that. So all of the backup documentation is within this
And,
agenda.
go ahead. The latest record of this was what date again? I know there was several of them in there, but it was 2024, right?
That is correct. From what we can tell, this news article came out in 2019.
Right.
And within the article, it talks about how he was sentenced to 3 years, I believe. Nick can
correct,
speak
yes, ma'am.
further to that. So that would have, depending on when he went in, that would have pushed it out to 2022, 23 of when he possibly would have gotten out. However, we have an affidavit from a contractor saying that he was working for
Right.
him during that time. I was hoping that the applicant would be here to be able to explain some of this.
If it's unexplainable, it might be why. So when a contractor the signing of the back of this is page 6, I guess, of the form.
On his application, sir?
Application form. When they sign this and it's notarized, what kind of culpability is there on somebody who falsifies information? I mean, how can you be incarcerated and working unless it's a work release, I guess?
So.
Miss Legal, can you help me?
I was waiting to see.
Miss Christie, I looked your way.
Well, it's, this is in what state?
So the conviction or whatever was in New Jersey?
Yeah, so.
But he was in
depending on New
Florida
Jersey-
working.
Yeah, it's, that was
Yeah.
something where he would certainly have to tell you, because I don't know. I don't know how he could, it doesn't make sense, as you pointed out. And you have the ability to weigh what's before you. And you should have the ability to ask him. Now, a notarized statement doesn't mean that the facts in it are true. It means that he swears that the facts are true, but it doesn't show that the contractor swears that the facts are true. But it doesn't settle the matter for you, because you would still need to be able to ask whoever wrote the letter, it's just a notary. And the notary is just saying, I swore him in and he swore to
Right,
this.
right.
So they have
But
no
he's
knowledge.
swearing into that these statements are true.
Right.
Is that correct? And if he states that they're true, but they're not true, I
Right.
guess the question is, I'm not trying to nail an individual down. I'm just looking at all these applications that come in. If people keep doing this, how can we how can we verify and trust and et cetera, that,
Well, that's what we've started working on these applications, is looking for more. This one was easier because the name was so unique.
right,
But seeing what I know that they've been working on, seeing what is out there easily available in Google, and at least in the local districts around us, the local licensing districts, and I believe that they can answer more to that, how they're trying to look deeper into what's out there now, because there is more information available to make it easier for us to cross-check it. And it also helps when it's a local, if you've got somebody who's vouching for them, that's a local contractor, that's going to help you because you know these people. And if we need to ask the contractor, is this legit? Did you really write this? That's certainly available as an option. It's going to be more complicated when it's people that aren't from the area.
as a part of housekeeping, maybe just general information as well, if one of our board members sees names that they recognize as supervisors or builders, do we have the ability to contact them to verify this ourselves as a board to answer our questions, or is that something beyond?
I wouldn't recommend that.
Okay.
What I would do is recommend contacting Jennifer
Gotcha, okay.
or Nick and having them
Okay.
just say, hey,
Just a thought came to my mind.
give this person a call.
Yeah.
This,
Yeah.
it's or if you just give them the blanket, it's okay to call these people and verify the statements that are within it.
Mm-hmm.
You don't have to say, I know this person or anything like that. You can say, hey, just call, if you want them as part of their background, they can call these contractors that are writing the letters for them or saying they worked for me and get further information. Now, if the person doesn't call them back or, they can come to you and say, I never heard back from them. But I did call him and he said, yeah, he did work there. Those are options that are available. I don't know if you're already doing that.
We have that ability, yes, ma'am.
I mean, I think that it's still fair to trust most individuals.
Oh, yes, it is. Yeah, we don't want to just. Thank you, Mrs. Reagan.
But as far as if they're putting false information in there, it is a crime if it's
Yeah.
false information and it's sworn to. It is perjury, but it's a second-degree misdemeanor. It's not
And we're
likely.
not-
Yeah.
The thing about ours is just more of the trust factor if we get these in. So I thank y'all for doing deep dive research then, because obviously
And we're I don't know what happened, but I think we were working on trying to get them better information, better criminal background information, but I don't know how that went.
So we did reach out to the state to attempt to obtain access to certain information. The information would come from the local, like state level and federal level. I did receive a response back, and there might be some other things that we have to go through to be able to obtain that. We're in the process of doing
Okay.
that. Until then, we are doing everything we can.
Sure. Yeah, I'm thankful for what you guys are doing. It just kind of makes us stop and pause for a minute. So, with the information that we now have in front of us, Miss Investigator.
I can tell you. He falsified his application. I don't think we should go any further. That's my recommendation.
I'll second that.
And we have,
I second
so
that.
first of all, we need to put it in the form of a motion then.
I make a motion that we don't move forward with his application. It stops where it's at.
That we do not approve.
Yes, sir.
Okay, the motion's been made to not approve. You can slow us down.
So he was previously approved, and so your motion would have to be withdraw the previous approval and not approve him going forward. You just withdraw his previous approval, basically.
Okay, I make a motion to withdraw the previous approval and not approve, make a motion to not approve.
All right, and we have a second, Ms. Mary?
Yes, I second.
Okay, any other discussion?
Do we need to say and not approve going forward? Or just not
No,
approve?
no, he could always come forward and clean this all up for you.
Okay.
But you can just leave it as today, not allowing it. Yeah, sorry about that, I know that.
That's good. Good question.
Thanks, Melanie. Thanks, Ms. Luna, for picking up on that.
Okay. Any other discussion? If not, all in favor, raise your right hand. All opposed, same sign. Seeing none, hearing none, motion is approved.
Good morning, board members. Our next applicant is Miss Kiana Williamson. Miss Williamson, if you will please come to the podium, state your name and address for the record, please.
Kiana Williamson. I have 4100 East 106th Street, Cleveland, Ohio, 44105, as well as 3501 Bayswater Drive, Pensacola, Florida, 32514.
So, board members, Miss Williamson appears before you today requesting to take the residential contractor's examination. She does appear before you with exactly 4 years of experience, having obtained her contractor's license in Cleveland, Ohio, March the 17th, 2021. This was verified by phone call to the city of Cleveland, and you will also find 4 years of her licensure attached to this as well. In light of what we were just discussing, doing further research and digging, it was found that there is a civil suit against Diva Builders LLC. It was filed on August 9th, 2024 by plaintiff Gulf Coast Living LLC. The suit is currently still open. Copies of those court documents are available for your reference as well to take into consideration. Staff's recommendation is to defer to the board for decision.
Can we have those pulled up on the screen for us here, the background research? Make sure you guys, anybody had a chance to look at these and wants to look over these?
I have a question.
Yeah, before we get, I'm sorry. Ms. Williams, would you like to explain anything to us before we dig in? I should give you a
Absolutely.
chance first. I apologize.
No problem, no worries.
Thank you, Ms. Mayor.
There is a complaint. The complaint has been put on hold. I was doing some sub work, some painting and flooring for another company, Ashley Restorations and Designs. She vacated the project early on. Mr. Burdick, which is Gulf Coast Living's owner, contacted me and asked me if I could just finish my part, and I said yes. I guess him and Ashley got into some situation where he couldn't find her. I have insurance. I presented him with my insurance before I started to do the small part of the job that I had to do. I'm guessing that he think that me and her are a pair.
Miss Williamson, I'm sorry to interrupt. Can you please just move the microphone up a little
yes,
bit?
absolutely.
You're very soft-spoken.
And one more thing,
Sorry about that.
we can't catch the name that you're saying. You're saying Ashley?
Ashley Restoration and Design is the contractor that I was contracted to do work on this on this project with. So he has my insurance, he has my licensure and this and that. So I guess in an attempt to get in contact with her, he put the suit on me, and they're sorting through that as we speak.
Did you have a permit on that job?
No, what I did was what I'm allowed to do within the city of Escambia right now, which was painting and taking out some floors for
Right,
that project.
right.
That's it.
No structural permitted
No,
work?
absolutely not, sir.
Got you. Ms. Mary, sorry, I just wanted to give her a chance to,
So in reading through all these documents, so as I was reading this last night, are they suing you for the whole thing? The
No.
whole project?
No, the attorneys as well as, I forget the lady's name, I want to say her name is Annie, at the DBPR, have come together and realized that this is not of my fault. That the other young lady didn't provide the homeowner with any insurance, any licensing, anything, and they're trying to contact her. As far as I know, they've narrowed it down to North Carolina. So I'm not sure what will happen once they figure that out. But initially, the only information that he had to put in his suit was my information that I gave to him. I insure all of my projects. I don't care if I'm just demoing. I get a bond of insurance, which I had for this project. I can actually show it to you all. I think I have it in my phone. And that's what he went to get the suit. So it's just a matter of sorting things out. I welcome all adversity. I'm upstanding. I've been in contact. I'm willing to follow through the entire process. I might also add that I've been doing this work for almost 20 years. My anniversary was yesterday of my company for 18 years, and I've not had a civil suit in 18 years until this, working for someone else, which is the reason why it's so imperative for me to come before you to ask for the competency card so that I can handle my business professionally without having to depend on contractors or false subcontractors or whatever, and find myself in these type of situations moving forward.
My next question is for staff.
Yes, ma'am.
One, can we see a copy of her insurance? And two, did you call the DVPR to verify any of this information by chance?
So we didn't know that the DBPR was involved in
Okay.
this part. All we had was the civil case. We didn't know that DBPR was part of it. We can reach out to DBPR on that if you would like.
Can we pull up the application?
Yes.
Ms. Murray, in regard to the insurance, typically that's something we would require after examination, so we have not seen that as of yet. We'll be happy to request that, though.
Thank you.
So Ms. Williamson,
Yes, ma'am.
in these questions, is there a reason you didn't disclose this, that it was something that was going on?
I didn't
Just-
know about it. I literally just got an email about it, and I can prove that as well, like 2 weeks ago,
Okay.
after this.
After you had already applied?
Yes, ma'am.
Okay. Oh, yes, you applied back in December.
Yes, ma'am.
So you told us you just done painting and flooring, is that what you told us?
Yes.
And they have here for 129,000 something?
That is what the other contractor.
24,000, I'm sorry.
Yes, that's what the other contractor was under contract for him to do. She asked me if I can paint. I had painted for her before on other projects.
Right.
That is what I specialize in doing personally myself, is like customized finishing, maybe an accent wall or something like that. So the whole contract, to my understanding, was for that amount. I received like $6,000 to paint.
So you did not, because on here it says the defendant, Diva Builders, I'm on page 2, Exhibit A10. Defendant is not qualified by a contractor license to perform construction work. And then the next line, number 11, plaintiff paid defendants $124,920 in accordance with the contract. Did you have a contract with?
No, I didn't.
And it says a copy of payment records for the payments made to defendant is attached as Exhibit B. So I guess what I'm saying is they're saying something different than what you're saying, because they have this independent contractor where it has Gulf Coast Living and Diva Builders.
It should be Ashley Restoration and Design. So I'm not sure who Mr. Burdick is. I met him through Ashley, like I stated.
Your name is signed on it, 1/17 of 2024.
I didn't come, I'm sorry, go ahead.
No, I'm just saying your name is on the contract that has you listed. This is Exhibit A. You're listed under independent contractor agreement. Gulf Coast Living and Diva Builders is listed both. And then at the bottom of it, there's 2 signatures. Lee Burdick would be Gulf Coast, and then it may be a computer signature, but it's a signature there. That's on page 12. Then Exhibit B shows all this money coming out. It says, it's got your name listed on some of them here that I can easily see. Here's a $10,000 one, there's a $5,000 one. Here's another $5,000. Here's a $15,000 made to Diva Build. All these showing made to Diva Builders according to their things, $2,000. Are you aware of all this?
No, absolutely not. To my
So
understanding.
they're showing that they have record here. Here's another 2,000. I'm just scrolling down through this. This is under,
This is
The-
from Bank of America.
yeah,
transactions.
complaint, the complaint against Diva Builders. It's way down near the bottom, like Exhibit A and Exhibit B. Page 10. Page 10 starts, I'm sorry. And then from there down. So,
And there are copies of the receipts as well from Bank of America,
Yeah.
the transaction.
yeah, if you go next, you see right there, $5,000. You see on the screen there? They're showing 5,000. If you scroll to the next one, it's $10,000. So there's 15,000. If you keep going, there's another 5. That's 20,000. You see what I'm saying? And there's another 15. That's 35,000. So I don't distrust you, but on this they've got you tied in. I don't know if you even realized it or not, but
So I had hired a private investigator, Good Faith Investigations, because I never received any of these payments. So even the account number that was online listed, what was supposed to be my account number, was not my account number. It was on, I believe, Trellis.com, not my account number at all. So what happened was, once this came through, and I want to add that I have documentation that I didn't even meet this man to sign that contract. And I met him on, I want to say like maybe around the 3rd of February. So when I seen these documentations in the complaint, in the email that was sent to me, I immediately got my attorney involved
Sure.
and got a private investigator involved because I never received these funds. And even though it says Diva Builders LLC, with my bank accounts, with my business bank accounts, and I have 4, one with Wells Fargo, one with Truist, one with Navy Federal, and one with Bank of America, my own Bank of America account. They have to CC me in the job name. I make that a requirement for my records to keep everything in order. None of that is on these transactions. So my investigators have been doing a lot of research to figure this out. However, it has come to light that this Ashley person was fraudulently taking work from other people, not me. I can prove that to the board as well. I have all the documentation.
One of the things that I've experienced is when you go to the bank to make these wire transfers, these descriptions, you can put whatever you want in those
Right, right.
descriptions. So it's not just, they
and
can
your
put whatever name.
and her contract was computer signed as well.
Right.
It appears to be on
Right.
page 11. Page 12. So somebody could have signed for you. There's a lot of questions here that we can't fill the blanks with.
Right.
May I interrupt? May I make a suggestion?
Yes, please.
Can we put this off until the next meeting?
I was
and
just
give-
thinking that.
Okay, yeah. and
We want
them
to
an
give you
opportunity to do some
time. First of
research.
all, we're proud for people to become licensed and do this. So we want you to be able to get there, but we also want to make sure that this gets resolved out, and you can understand that.
Yes.
And I think maybe by a month from now, I have a feeling you'll have a better grip on this too.
We're trying, but civil suits I've seen them go on for years.
That's
but
true.
We're trying.
But at least like DVPR, their research, they can, sign off that you've cleared, and you'll be able to get receipts from the bank to see if that deposit was, because they're showing them, on some of them, they show it went to an account with your name on it, but,
It depends on the amount because, like I say, I did receive some monies from him, but it was nowhere near $124,000.
Right.
It was like $6,000.
right.
Paint a shed in the backyard, move some debris, paint the interior, and do some stuff to the floor like repairs. That's it. It was nowhere near the
I
amount
was
of
thinking
that.
you were a pretty expensive painter for $124,000.
Exactly. I wish. Yeah.
Sincerely, though, I think that Ms. Christie has a good, and I want you to understand where we're coming from. This is just because of what we have in front of us. We'd like to see that,
Okay.
something positive in that before we go forward.
Okay.
Any discussion here from the board? Anybody like to ask Ms. Williamson anything?
I don't want to ask, I just want to, I guess, make a suggestion, or maybe I'm not allowed to, I don't know. Christie will correct me.
That's what I'm here
She
for.
will.
Would it be possible for her to have the ability to get the, I guess, whatever investigation paperwork that she has and anything from her attorney to show that this is their response and the rebuttal to everything, and put that together so that they can prove kind of their innocence in this, so that we've at least shown some of our due diligence that she's, doing what she needs to try to take care of this, because it seems like she might very well be wrapped up in something that's not necessarily her fault.
Right, an extension would give her that opportunity to get that information, and she would just need to go through the same process of turning it over to Nick, and he would include it as the background, and it'd get before the board, and the next time you hear this.
So I have a question, Ms. Christie. Should we approach this as just to hold this, or to let her come back at another time? What to deny for her to resubmit, or just?
Well, you don't have enough information to make a decision at this
That's
time
right.
based on your questions. And so I don't think she would have to resubmit. She could just add the documentation. It could come back before the board in our meeting
So we
next
just
month.
defer it today? We just
Correct.
Defer it, okay.
Yes,
all
sir.
right,
Yes, sir.
Okay. So I'll entertain a motion from anybody to whatever they would like to have.
I make a motion to continue this to the next meeting.
I'll second that.
We have a motion second for continuance. Any discussion? All in favor, raise your right hand. All opposed, same sign. Seeing none, hearing none, motion is approved.
So 30 days from now?
Yes, ma'am. They will stay in touch with you and try to get more documentation. Basically, we just want to see the direction this thing's going.
Okay.
That's the main thing. This is not a no. This is a, let's get some more information.
Okay. Thank you.
Thank
Ms.
you.
Williamson?
Yes.
That next meeting is May 7th. It's the first Wednesday of the month, so it'll be May 7th.
All right. Thank you.
Board members, our next applicant to appear before you is Mr. Alfred Chenard III. Mr. Chenard, if you would please come to the podium, state your name and address for the record.
Alfred Chenard, 917 East Maxwell Street, Pensacola, Florida, 32503.
Mr. Chenard appears before you today requesting to take the residential contractor's examination. He currently has 2 years, 3 months, and 25 days of experience in the field as a foreman under High Point DBR LLC. He also appears before you with an associate in science degree in architectural design and construction technology. You will find that attached on, or you'll find the transcript attached to the attachment for the application. Mr. Chenard did disclose by answering yes to one of our financial criminal history questions, and he did provide all corresponding documentation to that answer. So because of this, staff does defer to the board for decision.
Has everyone had an opportunity to read through? Any questions? Would you like to say anything to us?
No, sir. I'm good. Thank you.
Any questions from the board, or anyone have a motion for us? Tick tock, tick tock. Yes, sir. you speak to the mic, please? Thank you.
Are there any rules or restrictions from us providing license with the charges that are made?
Ms. Christie? Sorry, Jennifer?
So within our county ordinance, there is nothing that precludes you for approving them to take an exam from any kind of background or any kind of yes answer to any of those questions. There's nothing in writing that says we would disqualify them if they did X, Y, Z. It's at the board's discretion.
Could you tell us a little bit about your experience, your work experience?
Yes, started in November 2022. Pretty much, I love my job. They've given me the ability to pretty much do anything in the field, anything at the office. I've learned estimating, scheduling, pretty much everything.
This is just for an application. This is just to allow him to take the test.
Take the test.
That is
yeah.
correct. He is requesting to take the examination.
And once you take the exam, then you become licensed, and then you could, pull permits, et cetera.
But he would have to come back to ask for a license?
No.
No, if he,
This
so,
is this is the
it.
stop, yeah.
Okay, excuse me.
That's a good question. Oh, boy. Not sure whether to even say anything about this or not. The source of experience.
So I went ahead and looked up his case. It looked like he did 3 years state prison and finished that, and he hasn't had, I'm not finding anything to show that there's any additional. I was just gonna double check that. And so his case has been over for several years. And there was originally 3 charges. I can see that the state attorney reduced it to 2 charges, and he pled. He didn't go to trial. So he resolved it. That's all I can really tell you about that. As far as the determination, I think one of the things that you look for when I look at somebody's criminal history, when we look at it from the legal standpoint, is we're looking for dishonesty. This is a different type, and you would also, I think you're also looking for dishonesty in the record. Did he admit it? Was he forward with it with you? And often what we would say, did he take responsibility? That type of thing. And it looks like it worked out. It was reset often, but that is not unusual or criminal law. Dockets pile up, and I don't have any answers about that. But we could certainly pull off more documents if you'd like to review more on that case.
My opinion is this happened in 2013, and
Correct.
there hasn't been any repeat
Right.
violations. And if it was an issue, then most likely you would have a repeat violation
and Nick,
in that 12 years.
also, could Nick correct me if I'm wrong, he got his degree in architecture after that time?
That is correct, yes.
And he's been working with Mr. Lovato since 2022,
Correct.
correct?
I make a motion to approve.
I'll second that.
Sounds good. Any discussion from the board? All in favor, raise your right hand. All opposed? It was good.
Thank you. Appreciate it.
Thank you. All right.
All right. The next application to appear before you today is Miss Renata Swetzuk. Miss Swetzuk, please come to the podium, state your name and address for the record.
Hi, my name is Renata Chwetczuk. The address 5490 Cruzat Way, Pensacola, Florida.
Yes, Miss Swetzuk is applying for the residential contractor application for examination. And according to the information provided to us by Mrs. Swetzuk, she worked 5 years, 1 month, and 14 days at Grand Builders LLC under the supervision of Anton Zanikow. Her responsibilities include but are not limited to being the crew leader at Grand Builders LLC and the contractor Adrian Manecki at Grand Builders LLC with CBC license number 1261244, signed off on Mrs. Sedgwick work experience verification as well. Ms. Swetzuk, my apologies, application for examination was submitted later into the month of March. In turns, limited our time for more in-depth research on applicants' experience in the trade. And our team member Nick is going to go over those items for approval, that was found during research on Mrs. Renata Swetzuk.
So board members, as Mr. Mason was saying, because of the time frame to publish the agenda, we were not able to attach these to make sure the agenda went out in time, but I do have research and documents to provide to the board pending your approval to distribute those.
Yes, please distribute. That would be great.
Do we have one from Ms. Renata?
We need a motion to add it to the agenda.
I
Yes.
make a motion to add to the agenda.
I have a second.
I'll second.
Tag teaming. All in favor, raise your right hand. All opposed, same sign. Seeing none, hearing none, motion approved.
Were you also named in the case of your husband? Your husband is Albert?
Yes.
Were you named in that case as well?
No.
No?
No.
Board members, again, we are limited essentially to searching names and addresses, records as we can online. These are the documents that I was able to locate. You will see a notice of list pendings. This is based out of Ocean County, New Jersey. Notice that it is Allegra Homes LLC. And then in subsection 1, to enforce construction lien claim filed June 2nd of 2022 with the clerk of court through Suffolk County in New York. The next document you will see is also out of Ocean County. This is for breach of contract against Allegra Homes, also listing Ms. Cheswick. The third document I was able to locate for you is a suit filed by Aurora Contractors Incorporated between themselves and Allegra Homes LLC, where Ms. Renata is also listed. We bring these before you to review and then to take into consideration for approval or denial of the application.
Mr. Now, would you like to expound on any of these? You don't have to, but you have the opportunity to.
It was my husband's responsibility for all that. He, I was under the Allegro Homes name for a couple of years, maybe 2. Later was my husband was. So I was good. He did for what he did. He can
Can
be
you speak
here.
a little louder to the mic?
He can be. I know we separated. He can be here today because he's very sick. He went to my son for a visit for a weekend, and he got some infection. Also, he has very bad heart disease, so he can be here. I like to get my own, to have opportunity to own my own business under my name this time. My husband is not gonna be working with me. Like I said, we separated now. We're thinking about divorce. Maybe if I got the license, he can work for me. Maybe. I come to Pensacola like over 10 years ago with my kids. I have 3 boys. Then I opened a company named Renaland. I bought a couple properties in Pensacola, Milton, Perdido Key area. And if I got my license, I can build houses on it to sell it. Right now, I'm building my own house in Perdidoki, and like a homeowner. And I'm sorry for my accent. When I'm nervous, you know, my English is even
That's okay.
worse. I'm
That's okay.
sorry.
No, we're
I'm
listening.
originally from Poland.
No problem.
Yes, so I have a couple properties already bought under the name. And for a couple years, 5 years, I work with Adrian and Anton for their company, construction company. They speak Polish too, so it was even much easier for me. And I was watching mostly the subcontractors, watching their work, which was supposed to be done on time, according to the schedule. I was working by myself too, with my hands, doing some like painting, tiles, wood floor, some siding too, trims, something like that. And like I said, I started to build my own house. It's halfway done. Right now, you know, waiting for drywall. I told myself it's gonna be ready in 2 years, but right now I'm thinking maybe 3 years. It's always money problems, you know. And yes, I would like to get the license to be my own boss and support my kids, to feel myself safe and support me and my kids. Because I don't know what's going. Me and my husband, we divorce.
So I have a question for you. It says you've been working here in Pensacola area since 2020. Is that when you moved here?
Yeah. No, for 25 years. 5 years. 19.
It just says January 15th from 2020 to February of 2025.
19, not 1.
That's all right. That's okay. I'm not trying to pin you down. I'm just trying to see, because these lawsuits in New Jersey and New York
But my husband signed papers. It wasn't. I was nothing to do it with that, you know. I didn't know even what happened, what was happening.
So he was up there working during that time?
Yeah.
2024, et cetera?
So maybe Krista, or maybe you could speak on it?
I'm sorry.
Could you possibly speak on that? But the suit, if she was named in the suit, if she would be held accountable for that since she wasn't
If she
under
was
the
part
judgment?
if she was part of the company owner, if
Yeah,
she
but
was one
I
of the
wasn't in the court even one time.
I didn't see her name in the documentation with the suit.
It's here. Every one of them's got her name.
Well, from the husband for Jersey. Okay.
the problem is we can't see Jersey's
Right.
information, but that's what I was trying to see if I could find anything else, but I didn't see anything.
And Ms. Christie, you can help me. Is it accurate to say that if there's like, say, 2 or 3 partners in a company and someone goes to sue, they can sue each one individually? Is that?
It depends, well, that is well out of my range.
I understand, but I'm just trying to figure if
I tried to protect us from lawsuits.
If she didn't even know.
No, they didn't suit me, no.
Without records, we couldn't tell you whether or not she was served or how the corporation was set up in New Jersey. We can see one of the corporations, we can see the corporation she's talking about that she has here, the LLC she has here, the Rena Land. Just a quick look on the internet, and I found another company that has the same address, which is Coastal Premier Homes LLC. That's
Yes, it's the one I like to have.
And then there's another one there, same location,
Allegro.
Allegro Homes.
Yeah, it was my husband's business.
And then there was one from that location, also M&M Chapman Enterprises, but I don't know what that one is, because it doesn't have their name and it is inactive, but
I
it does
don't
list,
know.
it does list the same address. So I can pull those up in Sunbiz, but I don't know that it's gonna give you any information that's helpful to you.
And that's, I would just, if it was a possibility to have more documentation and information, because my biggest thing is I don't want to hold her accountable for her husband's actions or what he may have been doing without her knowing.
That's something she could certainly supply to us. If she would have those records, because they would have been served on them, on each one of them, so she could provide those records.
Because I fully support you wanting to support yourself, staying safe, and your children. And so if you didn't know what your husband was doing, which is that's, it could totally happen.
Right.
I want to make sure you're not being held accountable for you're in a separation right now, your potential ex-husband's actions.
It would be another situation that if you want to see that documentation, that she would need to provide it to you. Ultimately, while we do the research and see what we can find, the person who's making the application, is their responsibility to bring to you the documents that you have questions about, documents that would certainly be in their possession.
Is that something you would be willing to do, to bring the documentation?
Yeah, I think so.
Okay.
I do want to draw your attention to your screen. This is the address that Ms. Renata has listed on all of her documentation as her business address, mailing address, etc. This is the home that she has been building. The permits are all expired at this moment. This construction project started back in 2020. And this has been expired since May of last year. So it's listed as her business address and everything. It has not received an occupancy.
Did everybody catch that? Feels like we're back to a position of needing more information, and it's nothing against you. I would reiterate what Ms. Luna said, that we support somebody doing better for themselves and taking care of their family, their kids. We support that. At the same time, we have responsibility
Okay.
to,
I understand.
be very judicious with what we're doing. So, do I have a motion from anyone?
I make a motion to continue to the next meeting.
A second.
We have a motion and a second to continue to the next meeting. Any other comments or discussion? All in favor, raise your right hand. All opposed, same sign. Seeing none, hear none. We will move it to the next month.
Okay.
They will be in contact with you about
Okay.
supporting documentation
Okay.
to be able to help
Okay,
us understand better
okay, good. I understand.
where everything's
Thank
at.
you.
And your
Okay.
English is beautiful. You speak more languages than probably we do, so your English is perfect.
Okay, thank you.
Thank you. Is that it for the contractor applications?
Yes, sir, that'll conclude contractor applications.
Thank you, guys. Okay, let's go to something fun.
We're now going to move into our probable cause hearings. The first item is Brett Smith doing business as Apex Plumbing LLC, state registered license number RF11067884, contractor competency board complaint number 25011 COM. It's in regard to Michael Dolezal, homeowner complainant at 3400 West Lee Street, Pensacola, Florida 32505. This is a continued hearing from our previous hearing date. Mr. Smith, are you present today? And are you going to provide testimony for this hearing? So, yes, you will be, right? And Mr. Dolezal, are you present today? And are you going to be providing testimony for this hearing? At this time, I'm going to have both parties sworn in, as well as our investigator, Melissa Reber.
Do you swear affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? I swear.
I don't know if you want to rehear this case in the investigation again. I believe we do have an update from Mr. Smith as well as Mr. Dolezal, so it may be that you just want to hear from the parties instead of going through the complete investigation report.
Is it okay with everyone just to hear the update? Does everybody remember pretty clearly? He spoke up.
They just want the update.
Oh, yeah, so everything is backfilled, finally got all the paperwork completed, and, yeah, I mean, everything's good to go. I've been speaking with him and Melissa, and we're good.
So everything's been inspected?
Yeah, everything's been passed, everything was pumped out, it was abandoned the correct way, and it was just really just the paperwork. It was the main longevity of it. That actually doing the physical work wasn't an issue. Yeah.
So staff would like to just draw attention to investigators exhibits F, G, and H, as well as respondents exhibits A and B. Those are additional items that were not provided during the previous hearing because this was the permit, the getting in the inspection, those items. We would like to move those into evidence for this hearing.
Have a motion to move the exhibits into evidence?
I make a motion to move the exhibits into evidence.
Is that a second? Motion is second. All in favor, raise your right hand. Opposed, same sign. Seeing none, hearing none, motion is approved. This is the building permit for the conversion. And then the inspection report being finalized.
And as you recall, whenever we had this previous hearing, Mr. Smith was made aware of his permitting history and some items that needed to be taken care of. This is an updated permitting history. He did come in and get quite a few of those taken care of.
Yeah, we still got quite a bit of them to go over with. Like, we're still doing the paperwork. I didn't get them completed by today, but we still have probably 6 of them left. And I don't know if it's getting submitted in. We have a big pile of them we're going to bring into one of you, to get them all out of the way. Because with this and Sanders County, we're trying to get them everything cleaned up.
Mr. Dolezal, anything else you'd like to tell us?
No,
Mr. Smith?
is that
Okay.
it? We're good?
Mr. Dolezal, would you like to speak to the board?
Good morning. My name is Mike Dolezal. I'm here about 3400 West Lee Street. Mr. Smith with Apex Plumbing had the permit, finished the job. Everything's done. He's been paid. I'm happy.
That's what we were looking for. You're happy.
Yes. Yes.
That's important for us, for the citizens to be happy.
Mm-hmm.
Good deal. Well, I can tell you this DEP Health Department transfer for the septic tank continues to be an incredible nightmare. A week ago yesterday, I sat in the DEP office in Tallahassee with the number 2 person in there and explained all the headaches we're having, me and a group of builders, and we walked out of there with 0. And I know this is being transmitted, but that's okay, because it's very frustrating. He's told that permits are getting, Mr. Smith, you'll appreciate this, he's told that permits are getting submitted back to him in 11 to 15 days. Yeah, we document immediately, including personal examples way beyond that. So I appreciate your patience and understanding that at least part of this was out of control of a subcontractor, but it's an ongoing thing. we can't get permits because of it. You know, they're actually allowing us now to write letters saying we're waiting on the sewer permit before we, you know, to get our building permit. So it is a big issue.
Sure.
And there's no sense in digging deeper, but they had 2.5 years to know this transition was coming. And when it happened, they had no trucks and few trucks, and the trucks they had needed new tires. They had no lasers. They had nothing after 2.5 years knowing the transition was coming. So yeah, there's a little bit of uneasiness inside of us who are out in the field. So
I understand. I appreciate the board's help on this.
yes, sir.
And y'all have a good day.
Thank you. Thank you. Glad you're happy. Excuse me for venting there, but that's So we need a motion to cancel any
Well, so
disciplinary or
your
what?
determination at this juncture would be to proceed to a disciplinary hearing or dismissal.
Dismissal. Do I have a motion for either to proceed or dismiss?
I make a motion to dismiss.
Do I have a second? Second. Or any questions? All in favor, raise your right hand. All opposed, same sign. Seeing none, hearing none, motion is approved for dismissal. Thank you, guys. Thank y'all very much for making this happen. Yeah, see that we did move to the happy side. Let's continue this thing, maybe. If it gets this happy, Mr. Erd will stay. Okay, we're in a disciplinary hearing.
Yes, sir, Mr. Chairman. So our first two items are just going to be cleanup items, to let you know. The first one is Wade L. Hunter III, doing business as Lee Hunter Construction LLC, state registered license number RR 282812171, contractor competency board complaint number 240863COM. It's in regard to Julie Ricks, homeowner complainant at 215 Berry Road, Pensacola, Florida 32507. This final The board already made some determinations in regard to violations. This final order has been put on hold pending Ms. Ricks providing restitution documentation. It was supposed to come back before this board for a restitution determination. To date, we have received no information from Ms. Ricks. We're trying to make sure we clean this up and get the final order out. Ms. Reber, our investigator, has been in communication with Ms. Ricks and requested these items for a couple of months now, and we have received nothing in return. It's at the board's discretion on whether they want to just go ahead and let's issue the final order and make no determination for restitution this time, or if you want us to still hold on to this case and wait on documentation.
Any input from the board?
I think we have another case. Can we defer this to the end of the agenda? We have a related case, that I think might provide some other information possibly. So if we can just defer this to the end of the agenda, it's my recommendation.
You can wait on this one until later if the
Each
board would
individual
like.
case should stand on its own merit as far as we
Right.
making our determination, but we can defer it.
Maybe to another meeting, because I'm fine with her having additional time to be contacted or to bring the documentation in.
Ms. Ricks?
So, Ms. Melissa, for a month now, there's been no response.
That's correct. She's not answered. Yes, 2 months. She's not answered my text, email, and just as I was coming into hearing, a clerk handed me return mail, which was her notice for this hearing.
Could we potentially give her 30 more days or to the next meeting and then just let her know that this is the final?
We can do that, a continuance, is that correct? We can do a continuance.
Is there any research we could do to find out if she maybe potentially moved, or is anything sent electronically, email?
There have been text communications, phone calls, email communications, and no response has been received.
Okay.
So do you want a motion for
Yeah.
continuance?
I make a motion for a continuance to give her until the next meeting
Do I have
to
a
bring in
second?
this documentation.
Second.
I have a motion and a second for a continuance. Any discussion? All in favor, raise your right hand. All opposed, same sign. Seeing none, hearing none, motion is approved.
Our next item is also Wade L. Hunter III, doing business as Lee Hunter Construction LLC, registered license number RR 282812171, contractor competency board complaint number 240967 COM. It's in regard to Jeffrey and Cynthia Hedenberg, the homeowner complainants at 6561 Oak Cliff Road, Pensacola, Florida 32526. This also has already been before this board, and determinations were made in regard to violations and restitution. But during those determinations, the board didn't specify a time frame in which those items needed to be paid. That is why this is being brought before the board today, to specify time frames. Mr. Hunter was present during these hearings, so he is aware that that final order is out there, and it's on hold. In your backup, I did include a draft final order, which includes what he was found in violation of, and what was ordered in regard to restitution. We just need the board to determine how long he has to make payment on those items.
Has he made any payments?
He has not received his final order as of yet, because they were on hold pending other items.
I apologize that we did not include that. So what we need from this board is a time frame to which these fines and restitution would be paid. Could you help me with whenever it was, whenever we went through it? I don't remember seeing in our county ordinances like a preferred schedule type thing. This is pretty much left to the board's discretion.
It's left to the board's
That's what I
discretion on
thought.
this. This
what I thought.
hearing and these determinations were made in February.
Right.
And so you could take that in consideration of timeframes as well, that there's already been until today.
Right.
There could have been some kind of something
Right.
paid or done.
Right. 60 days of,
Yeah.
I just didn't remember there being some kind of a guideline that gave us like the
There
fees
is
and stuff.
not.
Okay. So we have a total of $20,700 something dollars. Anybody have a time frame you'd like to submit to us for a motion? Or would like to discuss it first?
Mr. and Ms. Hedenberg are also present today. They may want to make a comment in regard to this as well. If they do, or if the board would like to hear from them, I would need to swear them in.
Sure, they're here, give them a chance.
If I
Give
could
them
go
the
ahead and have y'all
respect
sworn
them.
in.
Do you swear affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Minnie Mouse came in. Don't put that on. Don't put that, don't put that on. Sorry. Would y'all like to address the board? Sorry.
So after the last meeting that you guys had, he talked to me outside and told me he would be more than happy to finish the job. So I talked to him and he texted me and asked me for a good day in January, the last week of January, So I gave him 2 days. He texted me back and said that day, Thursday, I think it was the 30th or the 31st, would be fine. He would call me before he came, but he would show up about between 11 and 12. Never showed up, never got a text or a phone call saying, you know, this happened, I can't make it today, can we reschedule? I've sent him several text messages back with no response. So, you know, him saying he would be happy to finish it, and I was giving him the opportunity, nothing at all.
There will be another one coming up because I went ahead and paid to put the windows in because I want to get the property insured, and I can't without windows in that piece of it. So I'm putting windows in. That will be another hearing again for restitution.
We're also trying to get estimates on what it'll take to finish the job from someone.
Yeah,
So
that's the
that'll
second.
be
I can't get contractors to come out. Emerald Coast, nobody will come out, and they don't want to clean up a job.
Right. So you've already paid him for the windows?
That was in the original contract. It was the
Gotcha.
complete room.
Gotcha. Well, I hate he didn't fall through. It's,
You know, I against my better judgment, I was willing to give him another shot, and, you know, he just,
well, it wasn't against good judgment. That's being a good, kind person, and don't second guess yourself for having a kind heart. That's somebody who takes advantage of it, perhaps, but
yeah.
that's not on you. Okay, any other thing you'd like to repeat? Does anybody have a question for the Heidenbergs? Heidenberg? Okay, thank y'all. So, do I have a motion for a time frame? It's already been 60 days. Let me just ask something, because I think what you're fixing to say, 2 days? No, I'm just kidding. Just kidding. Because we made this in February, and now we're 2 months ahead, like if we'd done 30 days from date, it would already be passed, or do we, in other words, is this determination of days based on the February date, or is it based on today's date?
From the date of the issuance of the final order.
Which has not been done
So when you
yet.
sign it, it'll be 30 days from that
Okay.
date, Chair.
All right, thank you. So he can say 30 days from, on this motion, and it not be already expired.
Correct, and since
Gotcha.
this is already drafted.
Right.
Actually, after this meeting, if you want to come over, we can have that signed today,
I will
since it's
sign it
already
today.
drafted. Mhm.
Okay, Ms. Gary, sorry, I just want to make sure we got ourselves clear on that.
Making a motion to make it pay within 30 days.
On both the fines and the restitution?
Yes.
Do I have a second?
And
I'll make a
what,
second.
I hate to pause y'all, but we also, within that motion, need what should happen should he
That's
fail
right.
to make the payment.
Penalty for that. So, and we can do things like, I mean, you can, I don't know if you can revoke license for this one, but you can suspend license, you can suspend permit and privileges. There's several different things that can be done.
If I went in and make a motion and then said if it does not pay, then you come back for disciplinary action, yeah, right?
No, this is disciplinary action. Yes, sir. So if he doesn't pay, we go ahead and state what happens.
And in previous final orders, this statement has been in there to bring him back for further disciplinary action or bring a person back.
So you can do that.
Yes,
I'm sorry.
y'all have done all types of final orders. Some of it is suspension, revocation, et cetera. But as Mr. Hebden was saying, there has been instances where it was to bring them back.
Okay, you can say to bring him back. I apologize. I thought this was it.
Make a motion for, to be paid within 30 days. And if not paid within 30 days, then to bring back for disciplinary action.
There we go. Now do I have a second?
Second.
Do I have any discussion?
Yeah, I'd like to discuss, disciplinary action as
Okay.
an option. Yeah, did we decide on disciplinary action today?
Today?
So that he'll know what the consequence is if he doesn't pay?
So you'd like to amend the motion to state
Yes,
that the disciplinary action be,
modified to, that we determine a disciplinary action so that he knows what he's up against if he doesn't pay.
can you give us
My motion is to amend the.
current motion?
The current motion to provide a penalty or what the disciplinary action is going to be so that he knows what he's up against.
But we need you to state that penalty. Not in other words, we don't need to be broad, we actually need to, is that right, Ms. Christie?
He's wanting to know what do you want the penalty to be for failure to act, to failure to comply.
Well,
That's what you're saying, right?
Mr. Gary made a motion for him to come back, and then we discuss it. But now the amendment to the motion is that we go ahead and establish that now.
Right, so the motion would need to include what do you want to establish?
So we would go back to Mr. Gary to make, okay.
So do you want a suspension, do you want a termination?
Yeah, what would you like to have? Suspension, termination, revoking of permanent privileges for so many days?
I'd recommend termination, but up for discussion.
This has been
Termination.
going on for how many months?
Oh,
September 2024.
Right, and that's why I'm favoring termination, because it's just non-responsive.
Okay, then I'll amend my motion to be paid within 30 days. If not paid within 30 days, then termination of license.
Revoking
It
of
would,
his
it'd
license?
be revocation of a license,
Revocation of license.
and the revocation is, let me double check.
I think you have to have a time frame,
Has to be
right?
1 to 5 years, I believe, but let me double check that since. It's an 18. I know, it's just that I'm looking at Municode.
It's right here, Christie. G.
Okay. Okay, so I just wanted to look at the specific language in Municode. And it says, the revocation of a contractor's certificate of competency shall be a period not less than 1 year, no more than 5 years, unless you find egregious circumstances. And egregious circumstances would be where you would have to be convinced that the safety of the public demands permanent revocation.
So then with my motion that I made, I just have to clarify the years, or does it automatically go to the minimum?
No, you'd have to clarify 1 to 5 years.
All right, then I make a amendment to my motion and say that he's gonna lose his license for 1 year if not paid.
So we have a motion for payment within 30 days, and if not, the license will be revoked for a period of 1 year? Okay. Do I have a second on the amended motion?
A second.
All right, a motion and a second. Any discussion? All in favor, raise your right hand. All opposed, same sign, seeing none, hearing none, motion is approved.
Thank you.
Thank you, guys.
So did you understand? So they've given him 30 days to make the payment, and if he doesn't make the payment within 30 days, then his license will be revoked for a year. Doesn't necessarily mean that you're gonna get your money, but it will prevent him from pulling any permits or doing any construction in the region.
I've gotta have this so I can go to court.
Okay, and so we'll have that signed and ready.
If Mr. Lister will hang out around after this, then we should have that to you today.
Okay.
Our next item is My D Tran, doing business as M&H Construction Services LLC, state registered license number RG 291103748, contractor competency board complaint number 250213 COM. It's in regard to Lin Yang Lee, doing business as Let's Meet Korean Barbecue LLC, complainant at 6235 North Davis Highway, Pensacola, Florida 32504. I see that Mr. Tran is present with representation. I do not see Lin Yang Lee in the audience. And just a reminder that Ms. Reber was already sworn. We're gonna go through the administrative complaint really quick so the board can get a quick reminder of what this case is about. I know that Mr. Hatler did provide us with some information last night, and I know that he would like to present that to the board. We do have printouts for the board on that item. But just let's circle back and go through the administrative complaint. Notice was sent to representation for Mr. Tran, and we did receive confirmation that it was received, and that is attached to the agenda. Probable cause hearing was held on March 5th, 2025. That probable cause hearing contained testimony and evidence about Mr. Lin Yang Lee. He hired the respondent to construct an expansion to his restaurant at the previous stated address. Issues arose with the project, and the property owner filed civil litigation against the respondent in June of 2021. The property owner and the respondent entered into a confidential settlement agreement that required payment in full by August 19th of 2024. The respondent failed to make the payment in full by the required deadline. Circuit Judge Jennifer J.
Fredovich.
I'm gonna let her say that. Executed a consent final judgment for the civil case on October 8th, 2024. Respondent has not satisfied that consent final judgment to date, and the property owner filed a written complaint with this board on February 17th, 2025. The board determined at the probable cause hearing that there was probable cause to believe that the respondent violated Code Section 1837 D17. That code section provides that a violation results from failure to satisfy a civil judgment obtained against the license or the business organization qualified by the licensee within a reasonable time for purposes of this article, including Florida Statute 49129-1R as amended. Reasonable time shall mean 90 days following the entry of a civil judgment that is not appealed. The board will consider a mutually agreed upon payment plan by the contractor as satisfaction of such judgment, so long as the payments are current. The board cited that the respondent violated this code section by failing to satisfy a consent final judgment issued in the Circuit Court of Escambia County on October 8th, 2024, and the penalty guidelines for violating this code section are a $500 to $1,000 fine and/or proof of satisfaction of civil judgment. That is all that staff has for you. And like I said, I believe Mr. Hatler has something he would like to present to the board.
Hey, Mr. Hadley.
Good morning, Ryan Hatler, 2908 East DeSoto Street, Pensacola. I have a happy ending at the end of the meeting. I'm always pleased to do that. As you know from the last meeting, we were working on getting some paperwork straightened out between the parties that would, in effect, satisfy the judgment. That has been done, and you're being handed now, and I believe staff can put up on the screen copies of the recorded liens. 2 liens were recorded in favor of Let's Meet, each lien for $50,000 for a total of $100,000, which is the amount agreed to by the parties in a signed confidential agreement between them. Because this is a public forum, I can't disclose the entire agreement, but the liens are indicative of the substance of the agreement between the parties. So in effect, this is better than a payment plan. It is a secured interest, securing his payment. And so if we look at Code Section 18-37D17, which is what's cited in the administrative complaint and guides the board's action on this matter, it says that the first violation is $500 to $1,000 fine and/or proof of satisfaction of a civil judgment. And it goes on to say at the end of that subsection, the board will consider a mutually agreed upon payment plan by the contractor as satisfaction of such a judgment, so long as the payments are current. And so I would submit to the board, this contractor has done the right thing. He has given better than a payment plan. He has given secured interest in real property. And so we are hoping the board will look favorably upon that outcome and that resolution and not impose a fine and accept the liens securing interest in real property as the resolution of this complaint.
What was the amount of restitution? I don't see it on here. Do you remember, Ms. Jennifer?
What was that, Chair?
What was the amount of restitution that was done, that was decided?
So the civil judgment was entered for $121,000. That was what was on
That
the
was what-
documentation
Gotcha.
from the judge.
And this is 100 of it that's been relinquished out. Ms.
Well,
Hadley,
this, the agreement,
250s is 100 and,
again, the agreement between the parties.
Right.
That I can't disclose.
Gotcha.
In full.
But what we have here is,
Says that the $100,000 of these 2 liens is full and final satisfaction of
Okay.
everything. So once the liens are paid out, then Let's Meet will, well, as each lien is paid out, as you know, they will be required to provide a discharge of lien. Or
Right.
satisfaction lien.
Right, for each
lien release, whatever,
property.
you want to call it. We call it a lot of different things, so however you know it, a lien release for each lien. And when the second lien is paid out, upon that, the case will be dismissed and a satisfaction of judgment will be filed by Let's Meet. And that will clean up everything. That'll be
Probably.
full and final completion and resolution.
Is there a timeline of the payment of the liens?
No, because it's dependent on completion of the projects, and Mr. Tran is set to have his permitting privileges reinstated April 10th. And so as soon as that happens, he can start the work on these 2 projects, and as soon as each one is completed and sold, it can't be sold without Let's Meet getting paid the amount of the
right,
lien.
they have a.
Is there a timeline on the completion of the projects?
I believe 4 months 4 months for each one. These are projects that are familiar, to M&H. They've done them before, and so it should be a routine project and timeframe.
So are you saying that you entered into a new agreement
Yes, there's a new
after
settlement
the
agreement.
Settlement.
after the consent final judgment?
Correct.
And that's been filed with the clerk of court?
we're not gonna file this settlement agreement. No, the resolution of the court matter and the judgment will be through a satisfaction of judgment that is recorded by Let's Meet after the second lien is paid out.
Okay, and in the meantime, it just collects interest? And
It's gonna be they agreed in the new settlement agreement, they agreed to an amount of $100,000, period. The interest can't run on a lien, because when you record a lien against a piece of property, that's for a fixed amount.
That's final.
And so he accepted security in real property to secure his payment in exchange for the extra $20,000 in accruing interest. Certainty, a bird in the hand, so to speak.
Forgive my doubting Thomas attitude, but what is the incentive for him to actually get this done? Because that would just mean that there's a lien on a piece of property that he could sit on for, from here to eternity at this point. I understand what the settlement is that you agreed to, but I'm still not following how that there is any fire lit for him to finish this.
That's
at
my
the moment.
concern as well. Just
Yeah.
making, like,
I mean, we've
to
drug it out.
ensure this will be executed.
We've drug this out so long, it's, I mean,
Well,
I understand the securing the property, but the property can sit there until the cows come home, and if he doesn't actually do the work, or finish it, or actually put it on the market and sell it, then.
While that is admittedly a factual possibility, I don't think it should be the default assumption of the board. I mean, this is a situation where Mr. Tran has come before the board consistently and tried to work it out, and I believe as an attorney, 2 liens on real property securing payment is just about as, close to a guarantee in life as you can get. I don't see any reason. I don't know of any facts or evidence as we sit here today that would justify the board's presumption as more likely than not that this property will just be allowed to sit and nothing will happen. Mr. Tran has come before this board in the past 6 months requesting reinstatement of his permitting privileges because he wants to get back to work. He is looking forward to April 10th when he can get back to work, and I think that these should be the indications to the board as to what is going to happen in the near future, not assuming that he will do wrong and do nothing.
But I think it's also worth noting that his permitting privileges were taken away due to his own actions. So it's not because the board just decided to take it away.
And he's, pardon the criminal analogy, but he's done his time and he shouldn't be continually punished or suspected for something that he has taken responsibility for and paid the penalty for.
And I completely agree with that. I just want to ensure that there's something established to make sure that he follows through and executes his promises. And with that, Christy, what can we do in terms of this in a time?
Sorry, we were looking up a number of things because.
Oh, no, you're fine, you're fine.
And so what you.
I should have just said go Gators, and I knew how to get your attention.
This weekend.
Yes.
I have to agree with you.
And this, so what we were looking at was we pulled up the permit to see who's doing the construction on the property, and it's a company by the name of Stanley DT Construction Services. That's who's got permits pulled. And I think we're looking to see what connection that is to this, to the Blue Sea Florida Investment Company. And we're not sure what the relationship is to Blue Sea to Mr. Tran, and that's what she's looking up as well. I mean,
Yeah, so Blue Sea Florida Investment LLC owns the property that the lien has been put on. The contractor that is building the home currently is the one that Christy spoke about earlier. I looked up Blue Sea Florida Investment LLC, and Mr. Tran isn't listed anywhere on this company.
When was the permit pulled that you're talking about? Because I suspect it was pulled after Mr. Tran's permitting privileges were revoked.
So that's correct. Mr. Tran did come in and attempt to obtain the permit. himself, and it was subsequently voided whenever, because his permitting privileges were revoked. And then Stanley DT Construction came in a couple of months later, or a month later, and obtained the permitting. So it's under permit by a different contractor.
Yeah, and that'll have to be closed out and a new permit pulled by M&H Construction.
You understand, I know you do, Mr. Hatler, that there's all kind of flags with this. It would appear someone is pulling permits for Mr. Tran to continue working.
Well, no,
It
I'm
would
not saying it
appear.
doesn't appear that way. I'm saying
It
that,
would appear.
that's not the reality. The reality, as I understand the situation back then, was because Mr. Tran couldn't get the permit, he was going to have this contractor perform the project, but it quickly became apparent that it was not going to be cost effective to proceed that way, and so they stopped moving forward under that permit. I didn't know the permit was still active.
And why is Mr. Tran not the signator for the authorized member on these liens?
But he's not an authorized person of the owner. It's whatever.
So the owner of
Mr.
Blue Sea
Doe-
Florida Investment LLC is doing it on behalf of Mr. Tran?
Well, I'm not privy to the private discussions or business dealings between Mr. Doe and Mr. Tran, but I mean, this is recorded. It's signed by Mr. Doe, notarized, so we know it's him, and it's recorded in the official records of Escambia County, Florida.
Still some smelly signs
I would
of
say
activity that's not kosher.
And it's just, there's no connection to Mr. Tran, and it goes here, so I'm trying to follow the little red ball.
Yeah, I would say that it is definitely an unusual situation, but it is not improper.
And we're not trying to say that, we're just trying to
Sure.
understand the information that's at hand and in front of us.
Yeah, I think my feeling and belief and assertion today is that these executed recorded liens are the most important aspect of this whole situation. I mean, it's like a mortgage to a bank. I mean, it is.
I can appreciate your point with that, Ms. Hatter. What the hiccup we're feeling is somebody else is pulling permits on projects that Mr. Tran has a contract on. And that is flags.
Yeah.
Mr. Tran has a contract with Mr. Doe for a project. His privileges were revoked, so he has found somebody else to pull a permit on that job. He has a contract signed to do work that he's not licensed to be able to perform, which is not legal.
Wait, I don't follow you there.
Mr. Tran has a contract with Mr. Doe to do work on his property, but he is not licensed properly to fulfill that contract at this time. So he hires or gets somebody to come pull permits to do the work, but he still has the contract. That's a flag.
But we don't
That's
know who
illegal.
hired the other contractor to do the work.
Well, we do know.
How do we know that?
There's no contract between the Stanley DT and Mr. Doe.
How do we know that?
Correct?
I don't know that. You're telling me that. I don't know that.
From research, I think that's going to be found to be accurate, but we will do the research then because, you know, there's something slimy here somewhere and we got to get to the end of this
Well,
thing.
I don't think that characterization is proper in this forum.
Well, it feels unethical. It feels against our law, our county ordinances, the state law. All of that. You have to be a licensed contractor in good standing to sign contracts. And when you do that, and then you're very intelligent, more so than me probably on some of this law stuff. You know that's out of the bounds.
Well, I don't know who this other contractor had a contract with.
Well, we can find out.
I was not privy to that contract.
We can find out, that's for sure.
So I don't know if it's helpful, but they were able to pull the Sunbiz records on that, and the company that has that's been pulling the permits is a gentleman or a company. The registered agent is Tung Pham, and the title manager is Dien Tran, Dien Tran. So I don't know. I mean, the manager of that company is Dien Tran, and of course, I gave you the registered agent. I think what I'm hearing the board, and I know it's how it sounds, but I think what they're saying is they can't see they don't see the nexus between the property owner. Why would a property owner who has no nexus to your client put a debt against their property? And that's what makes no sense. And I think that's what they're saying. That piece of the puzzle is missing, and they want to know what the answer is. And the only way they can know that answer is to follow up and to find out why Stanley DT is pulling permits on a property and somebody else is offering lien for payment of a debt that Tran owns. It doesn't add up, is what they're saying. So where's the connection? They're just looking for the nexus.
If he has no interest in it, if he has no interest in it, which is supposed to be based on everything we're reading, why would somebody stand up and allow a lien to be put on this property for somebody who has no vested interest in it? So there's.
Well, again, I don't know that the individual private business matters of these two gentlemen are before this board today. I understand you can ask the question, raise the concern, and not, express your frustration with not understanding, being able to connect the dots. But from a legal standpoint today, we are here on the administrative complaint for failure to pay a civil judgment.
Right.
The fine for that is $500,000 to $1,000. If you impose the fine, you can do that. This can all be over today. I was hoping that given everything we've done and the recorded liens, securing the payments, the agreement with the owner, that the board would look favorably upon this resolution and not impose the liens by considering the liens as essentially better than a payment plan as referenced in the ordinance. However, if you're not inclined to look favorably upon the liens as a payment plan essentially, and dispense with the fine, then you can just impose the fine today, obviously.
And from Mr. Lee's standpoint, he probably is better to have the bird in hand. I can see that. There's some shifting parts in here that's flagging us, and that's the concern about this.
I have a question, Jennifer. Whoa, I got really close to the mic, sorry. The tab that you just had open that displayed the names, there's a Tran on there. Is there an address, and is it the same as Mr. Tran here?
So on the LOA, we don't require addresses for authorized agents. So I do not have a physical address for
I was just curious
Mr.
if there
Tran
was
that was
relation.
listed.
And this person was.
So on here, on the Sunbiz documentation for Stanley DT Construction, it does have an address listed as 305 North Stillman Street for Mr. Tran.
Okay, Mr. Tran just informed me that the property owner is actually here with him. And so if you want to swear her in and ask her in a public forum about why she would be willing to do what you're asking about, that's on you. But she's here, and I don't think it's appropriate, but there's the owner right there.
I think that's lovely if she'd like to come up and talk. Thank you for offering that. If we can swear her in, and if she'd like to speak, she's more than welcome to.
Yeah, and I think it's in the best interest of getting a good settlement.
Ms. Christie, I would defer to get your input from our standpoint.
Well, I think the connection is what's missing for you to understand why someone would put this kind of money, give someone that they don't have a connection to.
Just wanted to make sure we're in our.
And I would remind you, part of the penalties that are available under this is the fine, and you can include the requirement to show proof of civil. So this is what he's trying to do with this, is show proof of civil satisfaction of the civil.
Right.
So that's the other half of it, besides it's a fine and or fine or. So.
And again, for the record, because I don't know where this is going, but for the record, I want to state clearly, I believe we've shown this.
And I can
And prying behind how, you know, in America, how much is this governmental body who's in charge of licensing allowed to claw behind the scenes into people's personal lives and dealings? I don't know, but there's a line somewhere.
There is, yes, sir. Our concern would be more somebody operating within their licensing privileges and operating outside of it.
And
We're
that is not
trying to-
before this board today, though, is my point. The administrative complaint is not on that. We are here on 18-37D17, failure to pay a civil judgment timely.
Thank you.
Based on what they've said, they have to make the determination whether or not what you're showing them satisfies the debt. And if they could just make the determination that it doesn't satisfy it, but I think they're trying to get to a place where they can say it does. And that is why they're prying, is they want to get to a place where they're comfortable saying, yes, this satisfies it. We don't have the other party here. And I don't know if he thought that he didn't need to come, but we don't have him here. So they can't just ask him.
I would submit that Mr. Lee's absence today is a strong indication of his satisfaction with the agreement between the parties.
But to be fair, that's also speculation.
There's a lot of speculation going on this morning.
That goes with the theme then.
If she would like to approach the board, then we're open for that. She would need to be sworn in, correct?
State your name and address for that.
First of all, she needs to be sworn in.
Yeah. Yes, I do.
Thank you.
Yeah, my name is Wando. The address is 4773 Ribor Lane, Milton, Florida, 32570. I'm the owner of the Blue Sea Florida Investment LLC, also the owner of two property on Bayless. My friend is my boyfriend, and I know he has a permit to original to build my property in Bayless, but his license was suspended for until April, and I need to find a Stanley to just do the foundation for me, because I don't want the property damaged. You know, it's everything ready, and we need to keep moving. But that's all I need Stanley do, just foundation only. I'm still waiting for my boyfriend to get the license back. I'm trying to help him to get everything back. You know, like, cause he been a really rough time in the last few years. But yeah, other than that, and that's why I agreed to put 2 lien on the property. That after he get the license back, and we get it done really quick, because we done the same project for so many times. It's not, you know, it won't take long, as long as he get the license. It take like 3-4 months.
To flip the house, I guess you call it, is that the
yeah,
right
that's
word?
how we do. And yeah, but Stanley just done the foundation for me only. And they don't do anything else. You know, I'm still waiting for him.
Thank you, Ms. Doe. Thank you.
Thank you.
So we have before us
Also,
the,
just some clarification, I'm sorry. The 2 properties that she's talking about, are those the 2 properties that,
the liens are on.
and the liens are, okay, and then that he needs to continue to do work on to complete, to then get money? Is that, okay,
To sell
just want to
that,
make
yeah.
sure I'm following.
It's like
Okay.
a flip, they're building something, yeah. So our decision.
I'm sorry to hold you up, but our court reporter just needs a proper spelling for her name. How do you spell your name? So Oanhdo. Okay, thank you.
OANH. H.
OANH.
And then last name D-O.
D-O. So our determination will be, is the 2 liens sufficient to satisfy the restitution, and then any fine or no fine, et cetera, to go along with that. Is that correct still?
So what is before the board is to make a determination on whether Mr. Tran violated this code section. And if you make that determination, then to determine what penalty you will assess.
But the lien that's here, we could also be determined that this does satisfy it. That's what the option is.
I believe that's the request from Mr. Hattler.
Right,
Is
right.
that would take the liens or what they are providing as proof of the satisfaction of civil judgment. Mhm.
And at that point, there would be no fines, right, Ms. Christie? That would be
The guideline allows for a $500 to $1,000 fine.
on top of, even if we say this satisfies?
Right, if you make a finding that it's a violation, then you go to the question, what's the penalty? $500 to $1,000 fine, which is the guideline, and or proof of satisfaction, and then you would make that determination, yes, this satisfies, or no, this doesn't satisfy. So the determination as to whether that satisfies, you don't really get there until you make a determination on disciplinary action, whether or not he's guilty of the violation of D-17.
So essentially two
steps.
Like outside of it, they could have come to a settlement. That's great, fantastic for y'all, but the violation is still here and we need to make a judgment as to the counts.
Correct. Mr. Waters is very good at this, at determining whether or not, I've seen him many times go regardless of what settlement has happened outside of here, he's still guilty. I've seen him do that before.
Right.
So it's still a decision you have to make regardless of their settlement outside of this. Because your determination is on that contractor.
Right.
It's not whether or not, I know that sometimes you don't go that far because parties are happy, and so it stops at probable cause. So you have to determine, is this a situation where the parties are happy and you don't want to, and you're just not going to make a disciplinary decision because the parties are happy, but you don't have the other side standing here to tell you that.
So we don't know if
So you have to weigh the evidence, you have to decide whether or not you want to do a finding of guilt against, on the one count for failure to satisfy. And then this is evidence that he's come back and made, the documents have been provided are evidence that would go towards the penalty phase. You have to determine first whether or not he failed within a reasonable time. And our code says 90 days. The state statute used to say 90 days. Now they've moved it, and I think it's actually in the FAC, and it says 60 days is the reasonable time. But I didn't locate that for you because our code, even with the bum reference to the wrong statute, it does say as amended. So it could be, our code recognizes 90 days. Did he satisfy the judgment within 90 days? And that's why it had to be brought back later than it was originally.
And I may be able to simplify this a bit. We will concede the violation. There was clearly a violation of 18-37D17, failure to timely pay the judgment within 90 days. We concede that. What I'm here this morning to do is to respectfully request that you look at the ordinance and where it says the result of a violation is a fine of $500 to $1,000 and or satisfaction of the judgment, proving satisfaction of the judgment, that the board ruled today, vote today, that it will say or, not and. So you are imposing a penalty or proof of satisfaction of the judgment, which I believe we have done today.
So based on that admission, you'd want to go ahead and do your take
Right.
care of your first step, which is the determination whether or not a
Determination of
violation
guilt.
occurred.
Do I have a motion to determination the violation of Escambia County Code Section 18-37D17? I need a motion from somebody, if that's what we want to do, that is in violation, admitted violation.
I make a motion that he was in admitted violation of Escambia County Code Section 18-37D17.
Right, do I have a second?
Second.
Okay, I have a motion second. Any other discussion? Okay, all in favor, raise your right hand. Okay, so now we have that completed. The second phase of this is,
For the record, it was a unanimous decision.
it was unanimous, I'm sorry.
Got to have the written record.
I was jumping ahead of myself. So the penalty phase guidelines is $500 to $1,000 fine and or proof of satisfaction of civil judgment, which we have record of 2 liens to help quantify that. So we can either have the lien, the fine and the submitted evidence to us, or just take the submitted evidence. And the fine, if someone wants to do the fine, it would have to be between $500 and $1,000. So again, our options to simplify is a fine of one of those amounts, between those amounts, and then we have the proof, or we just accept the proof and no fine. Is that kind of making sense? I know we've been all over the table here.
I make a motion that we go with the and it's a $500 fine plus proof of satisfaction, which he has done. $500 fine paid within 30
Okay.
days.
I have a motion for a $500 fine and proof of the settlement as evidenced. Do I have a second to that?
And Mr. Hebden did say 30 days is what.
And he said 30 days, pay within 30 days. Do I have a second with that? If there's no second, the motion will die. Is there a second? That's okay if it
I'd like
dies.
to amend the motion to 1,000 and satisfaction of lien.
So you would need the.
I'll second,
Okay,
so
so-
then that way.
Hold
there
on.
can
So
be
first
an
of all,
amendment.
slow down.
So the
So
first one.
first of all, we'll either have to get Mr. Gary to amend it, or we'll let that motion die and then you make a new motion. So is there no second to Mr. Gary's motion? Okay, the motion has died. So now I can entertain a secondary motion of,
I make a motion that the $1,000 fine be applied and the proof of satisfaction of lien
and the fine will be paid within
30 days.
within 30 days. All right. So I have a second motion now that would be a $1,000 fine payable within 30 days, along with the evidence given to us of the satisfaction.
And I need, what would happen if it should not be paid within the 30 days?
Okay, so you want to, well, we do that next, do we, or do we do that?
It's all included in one motion.
It's included in one motion.
Mhm.
And if it's not paid within 30 days,
Suspension, revocation.
Suspension and revocation of a license.
one of the two. Suspension, revocation.
Okay, hold on. Let me slow you down.
I
There's a
know.
conversation that's going on behind the bar that
Apologies.
the
I
court
said
reporter can't.
suspension or revocation. You can't have both. You have to have one or the other.
And so
Yeah, I'm just trying to make sure she's getting it on the record. Thank you.
She's fast.
So if we could have Mr. Sims, if you could do your motion again, so we have it clear.
I amend the motion to require a $1,000 fine and the satisfaction of the lien within 30 days or revocation of license.
For how long? Revocation has to occur between 1 and 5 years.
1 to 5 years.
1 year.
Okay.
Revocation, 1 year.
So that's, you're gonna, part of your motion, you're accepting the proof
Yes.
that's been provided as proof of the lien, so that, as proof of the satisfaction.
Yes.
Okay,
To reinstate it, I guess, would be a $1,000 fine payable within 30 days. If it's not paid, revoking of license for 1 year and accepting the evidence of a lien as satisfaction of the judgment.
that's what he said.
That's what he's saying. I'm just trying to surmise it to make sure that we're getting it right.
You got it.
Is that correct?
You got it.
Okay, so I need a second to that motion if there is one.
Second.
I have a motion, I have a second. Is there any discussion that we need to go into now with this? Okay, all in favor, raise your right hand. All opposed?
Thank you, board. Have a nice day.
Okay.
So for the record, Irwin Waters opposed?
Yep.
Okay.
Okay. So we have completed the third item.
I swear. There are no other agenda items?
Okay. There's no other items. We will be adjourned. Thank you, everyone.